Yeah, it's working fine. Good morning, everyone. Dignitaries on the dais, off the dais, doctors, students, ladies and gentlemen. I'm really dwarfed in the company of such tall doctors. And lawyers really look up to doctors only. They feel all others are clients. And I'll tell you a small story which happened to me. I had just taken over as Advocate General, and a very senior lawyer had fallen ill. COVID was at its peak. The RT-PCR test had just started, so I called a particular doctor in SB Medical College for RT-PCR, and all doctors were overwhelmed with COVID, and he was very evasive. And so my office told me, "Sir, how can he do this to us?" I said, "He can do this to you because he is a doctor." And AIIMS is very special. I don't know how many of you know Dr. Das, who was in AIIMS, and he's retired long time back. So when I used to visit him as a family friend, he used to always tell me that AIIMS is the most premier hospital in the country because the amount of research that happens in AIIMS happens in no other place. So before I begin, I would like to commend every single one of you for choosing to take on the most noblest of all parts, that is treating, caring and healing your fellow human beings when they need it most. The whole nation and the world is indeed grateful to the medical fraternity for their heroic service during pandemic. Just like the horror of pandemic, the tales of selfless, inspiring dedication, doctors, nurses, working round the clock to ensure humanity gets back on its feet, it's etched into the annals of history. The country has benefited enormously from your efforts, courage and perseverance, particularly during the pandemic. After 2 years, I can confidently say that things have started moving back to normal, and all thanks for which goes to the medical professionals. Vedic literature lauds medical practitioners and medicine as Vaidyo Narayano Hari Hari, meaning thereby a true doctor is a healer, is God, and true medicine is likely a sacred river of River Ganga. As I speak on how indebted the country is to doctors, it is difficult not to acknowledge that the country has not repaid its debt back. Rather, things have become worse on the daily for a practicing lawyer. Physical violence against doctors is on the rise. As per study made by the Indian Medical Association, more than 75% of the doctors have faced physical or verbal violence during their career as doctor. Social media has made things worse. Doctors are now subject to a barrage of abuses mentally. Violence against doctors have been noted by former Chief Justice of India, Justice N.V. Ramana, who noted that several false cases are being lodged against upright and hard-working doctors, and they need better and more secure working environment. Proactive steps needs to be taken to ensure that doctors are protected from situations which put them in any jeopardy. Being a doctor is hard enough a job with long working hours, intense work pressure, and the most negligible margin for error without there being added dangers from the very patients they are treating. The Union Minister for Health and Family Welfare told the Rajya Sabha on 5th of April 2022 that the ratio of doctors to population is 1:834. However, the distribution of doctors and nurses across the country is quite uneven. There are 4 times as many doctors in urban areas when compared to rural areas. There are also severe shortages in the country in the category of allied health professionals, including nurses, medical lab technicians, etc. As far as specialists are concerned, a large number of posts are vacant all over the country. Therefore, a major problem is the shortfall in the number and uneven distribution of doctors, nurses, specialists, and related health professionals. According to estimates, India needs close to 0.5 million additional medical healthcare specialists. To compound the problem, doctors practicing rural areas have to deal with terrible infrastructure, lack of security. There have been reported incidents of doctors being woken up in the middle of night by persons invading their house, pestering that they were treated immediately even though the matter may not be of much urgency. In my opinion, medical literacy of general populace needs to be increased. Very rarely do they understand that doctors and the practice of medicine is very difficult and unsure. Doctors engage in an analytical process of deducting what ailments a person may be suffering from. Based on the symptoms, they try to identify what most likely scenario is and treat accordingly. In some cases, a patient may not respond to a medicine, or it may be a disease which doesn't usually present with some symptoms. Sometimes patients are incurable, and there's not much a doctor can do. Medical literacy of the populace needs to be increased as the very first step. The second thing that needs to be done is passing of a special central legislation that defines and criminalized undesirable conduct of a practicing medical professional. Such legislation needs to be comprehensive and wide in scope, taking into account that violence against doctors is not just restricted to physical violence, but also includes verbal abuse and threats against family and friends. It must also provide the police with appropriate powers to immediately take preventive and protective steps against individuals who may engage in violence conduct against doctors. At present, 19 different states have enacted laws to protect doctors and other healthcare personnel from violence, which is cognizable and non-bailable offences in many states. Odisha, for record, has passed an act, namely the Odisha Medical Service Persons and Medical Service Institutions Prevention of Violence and Damage to Property Act 2008, which protects doctors from violence. Violence has been defined as activities of causing any harm, injury, or endangering the life, or intimidation, obstruction, or hindrance to any medical care service person in discharge of duty in Medicare service institutions. It penalizes violence against a medical service professional with imprisonment up to 3 years and a fine up to 50,000. However, this specific act is not invoked very often because of lack of proper awareness. There are no provisions proactively protecting doctors from violence. Moreover, the definition of violence itself is very narrow and fails to take account the verbal and mental abuse that doctors receive in their day-to-day lives. Thirdly, we must create a mechanism for making doctors themselves accountable for their actions and mistakes they make. Doctors are, after all, human. They may make a mistake one time or the other. I am of the view that violence against doctors would decrease if patients knew that in case of an untoward incident, they have access to an efficacious legal remedy which addresses their issues competently and ensure that they receive justice. We must be vigilant that such mechanism does not become a double-edged sword which shall be used to browbeat doctors or file false cases against them. Change in government policies like increased government spending on healthcare, improving the infrastructure of hospitals, stricter implementation of rules of law, punishment for violence under the Prevention of Violence Against Doctors in Hospitals, according to appropriate acts, can also lead to decrease in violence against doctors. Under Article 19 of the Constitution, every person has a right to practice any profession, which would extend to the medical profession. The right to life under 21 means right to live with dignity, free from exploitation. However, the violence against medical professionals, which is one of the most prestigious professions, has been on increase, which has demoralized them. Infrastructurally speaking, there is a prevalence of poor quality of emergency care in hospital, lack of emergency resources, laboratory services, workforce, etc., relevant and life-saving drug availability at the time of need. Emergency service capacity is critically low. Nursing homes run emergency services without proper training. Poor communication skills of healthcare workers. Administrative staff also compound and complicates patient interaction. Therefore, there is an urgent need to impart specific training to hospital staff and medical community at large on how to treat and engage them, their parents, their attendants in times of crisis. In my view, a public relationship training for medical community would go a long way in resolving the most abrasive situation quickly, amicably, without escalation. I've taken a lot of time, therefore I would now wrap up my speech, thanking you again for all your valiant service to the country and fellow citizens again for times gone and for times to come. Thank you for hearing me patiently.
Thank you, sir. Thank you, sir, for your guidance. Now I'll invite Brigadier Ashish Banerjee for his work on medico-legal aspects. Will the gavel protect the scalpel is his topic, and he will elaborate more on these aspects. Brigadier Banerjee.
Respected chairpersons, learned ASG sir, and distinguished guests and friends. Today is the auspicious occasion of beginning of Devi Paksh, so happy Mahalaya to all of you. Before I start speaking about my today's topic, I would most humbly solicit assent of learned ASG sir. Being a doctor and a student of law, I would request his approval so that I can speak little about whatever I have learned over the years, sir. So the question is, are doctors always amenable to violence, amenable to criminal prosecution, amenable to frivolous civil litigation, be it under Consumer Protection Act or be it under law of tort, which is ill-developed in India? I would like to limit my oration to these few headings. We need to know what is negligence to begin with, and therefore we would know that what is a medical negligence would constitute, how a civil and criminal negligence are different, how the judiciary interprets it, and the other things. Only point here that I would like to say is that in a very recent judgment, learned NCDRC in Vinod Khanna versus R.G. Stone Urology and Urology Center had stated that pre-printed consent forms would not be allowed. I would not discuss this case as it is sub judice, and Honorable Supreme Court has stayed on this judgment. But the fact is that we would little bit touch upon the ethical part of writing consent. What are the parts of the consent? Ethics generally deal on 4 basic principles. Deontology, that is, it gives you the basis for ethical action or ethical consideration. Consequentialism, what are the consequences of various actions that you take? Principalism, and as well as virtual ethics, which is like do no wrong, no malfeasance, no misfeasance, patient's autonomy, and so on. So let's begin our journey today. Okay, one slide somehow is missing. We would talk about the medical negligence part. Negligence is defined, or rather generally known as doing or omitting to do something which a normal person governed by those considerations which regulate the day-to-day dealings or normal dealings of human beings. If he has omitted doing that, then that is negligence. Or somebody who would normally do something in a particular given circumstances, if one omits to do that, that is negligence. So what brings us to the medical negligence? When a medical professional deviates from normal practice, that is what that would constitute medical negligence. Now, so far as medical negligence is concerned, in a case of Dr. Laxman Balakrishna Joshi versus Dr. Trimbak Bapu Godbole, Honorable Supreme Court has said that doctor must bring to task reasonable knowledge, reasonable skills, and reasonable degree of care. So what determines this reasonableness? The reasonableness is of a doctor to decide which case to undertake, what mode of medical practice he should employ or apply to the patient, what drug to be prescribed and how that is to be administered. This is wondrous responsibility on doctor that has to be done by a doctor. There is no negligence on the cause that his opinion varied with others. There is no negligence if somebody says there would have been better modalities of treatment available and doctor did not apply that. There is no negligence if somebody says there would have been some other doctor who would have done this treatment in a better way. No negligence. There would be no negligence if there is just a casual omission, an accident or difference of opinion. A doctor always ensures that the care is given. A medical practitioner never promises cure, but he always promises the best care possible. Before a forum, before a court of law, an applicant, an aggrieved person need to prove three things. There had been a proximity of care. There is a duty of care between the doctor and the patient, and that this care has been breached by the doctor, and this breach resulted in injury. Unless there is an injury, no negligence claim sustains before a court of law. So how do we differentiate? How did the civil liability evolve? In this, I would just mention few cases. We have in India have banked upon various judgments that King's Court or Chancery courts have given in United Kingdom. Initially, the standard of care was determined by Bolam versus Freeman medical authorities, in which the patient was restrained before given an electroconvulsive therapy. It used to be believed in those days that ECT would be ineffective or less effective if muscle relaxants are given. He was restrained severely, and when the ECT was applied, few long bones and some rib cages got fractured, and there lied the medical negligence case. The doctor, the expert advises that this is a common practice and there has been no deviation. Just because some other avenues or modalities of treatment exist, that does not mean that this practice was bad or this practice has been stopped. Therefore, the court decided no, since it is one of the usual practices, the standard of care has been given and no negligence. However, over the years, this got changed. In Hunter versus Henley, it was decided, what happened in Hunter versus Henley, an injection needle got broken while giving a procaine penicillin intravascular injection. Again, this is an accident, so the court decided against the applicant and said doctor is not negligent. But things changed. In Sidaway versus governors of Bethlehem Hospital, what happened in this case? This gentleman had weaknesses and pain in his upper limbs and giddiness. It was found that there is some listhesis between the upper cervical vertebra, and a fusion was prescribed. There is chance of causing hemiparesis or hemiplegia while undergoing this operation, but the chance is less than 0.1% of this complication. Doctors did not inform him about this complication. However, luck was not in his favor. The gentleman developed paralysis. But since the chances of such paralysis is very minimal, the judiciary again adjudicated the matter in favor of the doctor, that their professional capability in deciding what to be disclosed and not is supreme. But again, gradually the attitude of the persons and the perception of judiciary changed. In Mrs. Montgomery versus Lanarkshire Hospital, Mrs. Montgomery was a diabetic patient, a thin-built, short-height lady who was expecting her baby. Doctor did not inform her about a shoulder dystocia, which is about 10% of the causes that can complicate the vaginal delivery. The doctor accepted that in the court of law and said, if I keep on doing so, nobody would go for a vaginal delivery. No diabetic lady would go for a vaginal delivery. But this time court said no. There was no emergency. This risk, even if remote, should have been told to the patient. She should have exercised her right to have gone for a cesarean section. So therefore, thereafter, things undergone changes and came Bolitho's case. Bolitho versus City of Hackney Health Authorities. Young boy was diagnosed from suffering from croup. Doctors did not intubate him. He kept on having vexing and waning complaints of respiratory arrests. Finally, he succumbed to his ailment. 3 doctors examined by the court gave opinion in favor of not intubating. 5 doctors examined by the applicant gave their advice that he should have been intubated. Here the court said that doctor's advice are mere evidences. Court is not to go by a mere advice only. There should be a logical conclusion, and there should have been a competitive examination between various options, which the doctor failed to take. And thereby, the doctor was adjudicated negligent. Over the years, from Samira Kohli versus Dr. Prava Manchanda, from Vinitha Ashok versus Lakshmi Hospital, Bolam's test has been said goodbye, and people are migrating to Bolitho's case. Therefore, there should be a competitive evidence of the options examined and used by doctor while dealing with the matter. What are criminal negligence? Please understand, there have been almost 130 years since IPC has been postulated. Doctors have been put behind the bars, but not for medical negligence, ladies and gentlemen. They have put behind the bars for doing cross-pathy, quackery. They have been put behind the bars for not adhering to statutory provision in PCPNDT or MTP Act or things like that. So please be rest assured, for medical negligence, criminal liability does not come through. There had been barrage of cases. Because of paucity of time, I would not discuss those cases. However, Jacob Mathew and State of Punjab remains the mainstay, wherein the court has directed 3 things. The Honorable Supreme Court realized that a learned ASG has very lucidly brought out that there had been Epidemic Disease Act, Section 4 prevents any negligence on Epidemic Disease Act. The establishments, medical establishments, 21 states have so far enacted the law against the violence and destruction. But problem is that how many police personnel know about them? I can assure you not many, even probably none. The Supreme Court way back in 2005 anticipated this situation. Honorable Supreme Court gave directive stating that a private complaint may not be entertained in a court of law unless that has got reliable medical advice supporting negligence. Sustainable medical advice saying that there had been a negligent act. An investigating officer should not pursue the matter, lodge an FIR, unless he has obtained an opinion of a government doctor of the same specialty. Please understand, interpretation of statute says may not, option is, the discretion is with the court. But when they talk about the investigating officer, they have used, the Supreme Court has used the word should not. It prohibits an investigating officer that without a medical advice, he would not start his investigation. And lastly, the doctor would not be arrested indiscriminately unless there is a incriminating proof before the IO or investigating officer to do so. These are three protections that a doctor have. Even a legislature does not have this protection. Prabhat Kumar Singh versus State of Bihar. FIR quashed. Judgment of Patna High Court quashed by Honorable Supreme Court on this ground itself. So far medical opinion has not been obtained. It's a matter of 2021. And legislature has only few days, maybe about 3 or 4 days, if a case has been initiated against him, the speaker allows him to be prosecuted or proceeded against, not against doctors. Huge reprieve. You have enough time to defend your case. So therefore, the criminal negligence is only when you don't have the expertise to do something that you have done. Or if you have expertise but you did not apply it, and the negligence has been so gross, there has been an absolute, what should I say, lack of human belongingness or complete lack of feeling of a patient's life and his well-being. That is beyond any compensation. Then only it's a criminal negligence and not otherwise. So therefore, the civil liability vis-a-vis criminal liability, which I have already discussed. Now this is where actually we start our day. I dare say that doctors now need to prepare their lawyers for the courtroom. Lawyers don't know medicine. So the doctor has to prepare him, weapon him, arm him with enough material so that he can face the courtroom appropriately. Before that, we need to inculcate awareness amongst our staff. We must take all on board. What is the expectation of the hospital by the patient, and what can be hospital can expect from the patients? I have seen now the hospitals are run by third-party administrators. Hospitals are run by corporates. They say we pay TDS, don't involve us in a medical negligence case. Involve the doctors. No. Vicarious liability exists. All hospitals have to be prosecuted. They must understand that. They should have people who would do bill negotiation, who would manage these unruly patients, who would manage police, have a liaison with the police. That is very, very important. Data protection is very, very important. Ethics says, doctor says, can we? Ethics says, should we? So please understand, you are dealing with digital patients nowadays. Patients come with their mobile phone in their pocket. It is switched on. Please don't say anything that you have not put in writing. Please don't criticize other doctors. Please don't believe them. I have seen many gynecologists. This is a specialty which is litigated maximum other than anesthesia in medical negligence cases. A patient says, कितनी दिन की pregnancy है? पहली बार आपके पास आया हूँ. या मेरे को 6 महीने का pregnancy है. Doctor endorses that in the case. Please check from the hospital records. Don't believe a patient blindly. Many things changes. Also have a record. You keep the record. Ensure that no one comes to you consultation with his mobile phone. No recording permitted. If you are recording, mention that the consultation is recorded hereby, and it would be kept in a digitized form in the hospital, would be provided to the patient if they ask for. Don't allow them to record anything that can be doctored. So therefore, this is very, very important to have your own data. Have the data. Whenever patient asks, give it within 24 hours, within 48 hours. Don't hold it back. Evidence-based medicine practice is essential. Patient's autonomy, doctor's experience, and research must combine together to give you the answer for evidence-based medicine practice. Bill negotiations to be done by experts. So therefore, when there is a litigation, first time is that you get a notice from the litigants, please take legal advice, give a elaborate reply. At times it finishes there only. Don't succumb to the pressure that you must give him compensation outside court settlement if you are clearly not negligent. If you are negligent, ensure that there will be a memo of this out of court settlement. Then only go for out of court settlement, not otherwise. Make these things important dates and events chronologically. Please understand, law does not debar an MBBS doctor to do surgery. Law does not debar an MBBS doctor to do a cesarean section or do a delivery. Only thing is that MBBS doctor must not say that he is an expert. He must say that he is trained in doing all this. It has to be documentarily available. And also rebut each and every allegation stating that patient has no knowledge about medical practice and that the complaints made are based on his whims and fancies. Real consent is the origin of UK against informed consent. Court has time and again, in Samira Kohli, in Vinita Ashok and other cases, enforced that we must practice real consent. Everything need not to be disclosed. However, any life-threatening complications that may be even remote, like that can lead to loss of vision, a particular treatment, that can loss of hearing, acute hemorrhage, massive hemorrhages, that whatsoever remote they are must be disclosed to the patient. Stereotyped consent forms to be avoided. There are many consent form formats that is available. There are generally 4 parts of a consent form. In part 2, all essential information must be given, type of operation, the doctor who is operating or anesthetist who is giving the anesthesia. You must give special care if it's a difficult case, like a case of diabetes with ruptured appendix. If there would be prolonged illness, that has to be mentioned in the case sheet. There may be partial consent and partial refusal. A pre-counseling must be contained in the consent form, that you have asked the patient that this partial consent may go against his health and other benefits. Independent witnesses, if is kept, they has to have a copy of their Aadhaar card or some identity proof has to be taken. Only thing that I would say here is, unless a doctor is practicing quackery or cross-pathy, or he is violating specific provisions of PCPNDT Act, like not filling up Form F for PCPNDT Act, not filling up Form C in MTP Act, in Transplantation of Human Organ Acts, and other things. Also, we must be aware, now there are litigations taking place under various heads, under section 336 to 342 of IPC, involving causing hurt, grievous hurt, willful confinement. Even section 39 may be invoked, especially in case of Magic Drug and Remedies Act. If there are expired drugs given and if there are fictitious drugs, if the doctors fail to inform police authorities, a litigation may start. So we should be well aware about all these situations.
Brigadier Banerjee?
Yes, I am finishing. So with all this, we need to stay ahead. A tumor board, the medical legal aspects is not crystallized. Only thing we need to know, if there is a tumor board constituted, whether the patient know about which specialties would be involved. Does he know that his data would be shared? Does he know that what are these multi-speciality team would be only in advisory capacity, needs to be brought out clearly in the consent form. And if we do things correctly, I'm sure the days would be not far. The law would be very sturdy. in labeling a doctor with criminal liability or even with civil liability. We must not falter in our processes. The processes are streamlined and straitjacket. If our processes are correct, benefit of doubt always goes to doctors. And Gavel would definitely protect the scalpel. Thank you, ladies and gentlemen.
Thank you, Brigadier Banerjee. You brought out Bolam versus Bolitho very nicely, and that is how the things are progressing further. But the courts are again protecting all of us from these acts of violence as and when they are happening in our favor. Now, I invite Professor Mahesh Devnani to give his deliberations on RTI Act 2005 and problems thereof, and what doctors should do and what doctors should not. Professor Devnani.
Good morning all, and thank you very much, Colonel Rao sir. And thank you also to Dr. Jawahar and his team. This has been a wonderful experience till now. So we also conduct a CME on legal issues in which we cover some of these topics, and we'll send that invitation as and when we organize this. But today we'll discuss a little bit about the RTI Act. So we'll switch the gears from the criminal negligence, civil negligence and other issues of violence to one of the administrative matter which most of the hospital administrators and government setup especially face on day-to-day basis. So what I'm going to discuss is based on my experience, because in my institute all the departments have a CPIO, that is a Central Public Information Officer, and most of them are clinicians. But when they receive the request under the RTI Act, they most of the time contact us that what should we do in these cases. They are asking for this type of information or that type of information. So I'll just share so that it might be helpful to many of you who are working in the government setup and facing such problems. So these are some of the dilemmas that I have come across. People have talked to me, and then we have searched on, and we have replied to also on many of these queries. So let's start with this one. Okay, so I'll not go into the Right to Information Act, but the Right to Information Act provides the setting for the practical regime of right to information to citizens. Will it be available on this also? No, so okay, no problem. To secure access to information under the control of public authorities and in order to promote transparency and accountability in the public sector. So the Mahatma Gandhi once said that the real Swaraj will come not by the acquisition of authority by a few, but by the acquisition of capacity by all to resist authority when abused. And that is what the motto is of providing this Transparency Act. Now, what is difference in healthcare? One is the fiduciary relationship. Fiduciary relationship is in many other professions as well, for example, in law. But in healthcare, it is the relationship between the care provider and the patient, and we'll discuss a little bit in detail about this. The situations where the CPIO is required to evaluate if a larger public interest warrants disclosure of information or not. And the third is information many times that is sought pertains to the life or liberty of the person. Now, these are some of the dilemmas that I'm going to discuss that many of the clinicians have talked to me. Is the information sought exempted under the Act or not? If exempted, how to communicate it? What if the matter is sub judice or under departmental investigation? Can that information be provided or not? How to deal with the third-party information requests, especially if someone is asking about the medical record of others? Information is held by some other colleague who is not providing it, on which the CPIO has no direct administrative authority. What to do if the information requested is varied and long and in the form of asking opinions or asking questions? What to do if someone is asking some information repeatedly, same information is being asked repeatedly, or it's being transferred from different authorities to which he has asked the same information? What to do if the information is not available with the person? What if there are limited resources available with the department, and then there is a routine work they have to do, and they ask us that whether we do our clinical work or we do this work as well? And the information sought concerns to the life and liberty of the person. So how to navigate these dilemmas, and some of the slides may be crowded because I'll quote some of the CIC judgments as well, so bear with me. So one of the section of the Act itself says that the public authorities should suo motu declare information, and that is under section 4. And it saves much of the time, not only of the institute, but of the information seekers also, because if the information is already declared, is already available in the public space, they do not resort to, submit applications. And the Act itself tells us that what is the minimum that one has to disclose, and no one is stopping us from, disclosing information beyond that, as long as it is not exempted. But what we have seen that most of the hospital websites would not provide many of the informations which can be provided. So one thing that PGI has done in this regard is that we have an employee corner, because what we saw that most of the information seekers are from the institute itself, who are asking information for their administrative matters or some of the inquiries or something related to them. So now all the office orders, as long as this information is not exempted, is declared, is available under the employee corner, and any employee can go and see what are the various orders that have been issued over the time, office memorandum, etc. And then there are other things that are pertinent to the patients, which they ask many a times: what are the services available, what are the statistics, how many patients you have seen, what type of patients you have seen, and that information is freely available on the website. Now, fiduciary relationship. So the section 8(1)(e) exempts the disclosure of information under fiduciary relationship, but the Act itself does not define the fiduciary relationship. And this is one of the smallest Act, and I would urge everyone, if you are in this field, you should read this. But in one of the CIC judgments in the Rakesh Kumar and others versus Harish Chandra, the CIC has defined the fiduciary relationship. It says that it is often said that the fiduciary relationship is easier to illustrate than to define with precision. The word fiduciary is derived from the Latin fiducia, meaning trust, a person who has the power and obligation to act for another under circumstances when required, total trust, good faith, and honesty. When the patient is alive, and if someone is asking information about that, we just cannot provide it, because it is not only under the fiduciary relationship, it is a third-party information as well. But in one of the CIC case, when the applicant was denied information of her husband with regard to his treatment, that is what she asked. So judgment said that information denied since the information is being held by the doctor in a fiduciary relationship. However, the appellant was advised either to get an authorization letter from the patient permitting his wife to collect the information, or get a court order declaring the wife as a legal guardian. So many a times, if the patient is incapacitated or is not in a situation where he or she himself can get the information, in those situations the legal guardian can be provided the information. Now, if the patient is right, the same situation, we should provide the information to next of kin or the legal heir. And we just can't say that because it is held in the fiduciary relationship, we cannot provide. Actually, this happened in one of the cases, so CIC said that provide it. And routinely, the government hospitals provide information to next of kin or the legal guardian or the legal heir after taking the authorization. In fact, in the erstwhile MCI Act, it is written that the hospital should provide information in 72 hours. But I don't know, many a times patients are not aware of this, and they ask the information about the medical record through the RTI Act. Now, optimal use of fiscal resources is very important. Many a times long and very varied information is asked. So in this, the appellant sought for copies of documents and varied other details in 62 serials covering the entire gamut of functioning of the company. So the CIC in this held that the information sought is so voluminous that it would definitely cause a lot of pressure on the resources of the organization. The appellant is at the liberty to ask for specific information which would not cause enormous time and effort to collect and furnish. So many times CPIOs are not aware of such decisions, and they start collecting and collating all that information available even in different areas, in different files, in different places. Although the spirit of Act is to provide the information, we need to keep in mind that the spirit is to provide the information, but it should not impede our overall functioning of the organization. So Act itself says, the section 7(9) says, an information shall ordinarily be provided in the form in which it is sought, unless it would disproportionately divert the resources of the public authority or would be detrimental to the safety or preservation of the record. So do not apply this blindly, justify it by providing details. For example, in one of the decision, the CIC said that while the information was voluminous and it was denied, the option should have been given that these many pages the information is spread in, and then the applicant can decide whether he wants it or not, or can come and inspect. This also we need to keep in mind, that we justify our rejection or denial of information or refusal of information merely quoting the Act or merely quoting a section or the subsection of the Act is not enough. We need to justify how that subsection applies in the instant case. Now, this is a case in which the applicant had applied for a long list of varied information for last 20 years, and the CIC observed that this amounts to making a mockery of the Act. Asking diverse and lengthy information seemed to be designed only to put the public authorities under undue and uncalled for pressure, dismiss the case as frivolous and inconsequential. During the COVID, people were asking for information, 30, 40, 50 serials, and serials does not bother us, but many times they were asking information from different departments in single. In one of the case, the nodal CPIO of the PGI actually transferred the application to 42 CPIOs within the institute. So you can understand what kind of information the applicant had asked. And the nodal CPIO could have used, could have quoted these decisions and could have said that please ask specific information, or you are at the liberty to come and inspect, and then we can provide the information that you ask. But we should keep in mind that if we are giving this option to the applicant that you can come and inspect, because there is a provision, we should do it within 30 days of receiving the application, because after that, whatever he said that we need this, we will have to provide this free of cost. In another case, the applicant had filed 5 applications asking for all the records regarding various services and categories of staff. The judgment was asking for all the records regarding various services and categories of staff only amounts to making a mockery. RTI Act does not mean that the public authorities are required to entertain to all sort of frivolous applications. Repeat RTI. Many times it happens the person is asking same information, just changing a few words. So on that also, CIC have given decisions that even a single repetition of RTI application would demand the valuable time of the public authority and as well as the first appellate authority if the case goes to the first appellate authority. Every repetition of RTI application which was earlier responded to will be an obstruction to flow of information and defeat the purpose of the RTI. The citizen has no right to repeat the same or similar or slightly altered information request under RTI. An applicant or appellant repeating the RTI application or appeal either once or multiple times, suppressing the fact of earlier application and receipt of the answer, the CPIO of public authority may reject it forthwith after intimating it along with reasons. So we do it quite often. If during the COVID, what was happening, that the same application was coming from different sources. Ministry was also forwarding it. The state governments, nearby state governments were also forwarding it to it. The same person had submitted same application to different public authorities and they were being transferred to us. So if we had responded to one, we were rejecting the repeat RTIs. The severability is another. Many times we cannot provide all the information that is available with us. In that case, we can sever the information that is exempted and can provide the information that is not exempted. The sub judice matters, many times we have seen that CPIOs just blindly refuse to provide the information stating that this is a sub judice matter. But that is not the exemption. Is the exemption 8(1)(e) says that if the disclosure of information can impede the process of justice, then only we can refuse the information. Merely the matter being sub judice is not a ground for rejection. So third-party information, again, many times I have seen the CPIOs fiddle with this, how to provide this third-party information. We need to understand that whenever a third-party information is being asked, whether it's a patient record or otherwise, the CPIO's first responsibility is to see that whether this information can be disclosed having a larger public interest or not. If the CPIO has decided that this is exempted and does not need to be disclosed, the CPIO doesn't have to contact the third party for asking whether this can be disclosed. CPIOs blindly send all the applications which are asking for third-party information to the third-party information and then wait what the third-party information says, that whether this information can be given or not. The CPIO has to do it only when the CPIO intends to disclose the information and contact the third party to ask, I intend to disclose, what is your opinion if there is any objection on that. And once the reply of the third party have been received, the CIC over the period and the various courts have also said that the CPIO does not blindly need to follow what the third party has said. The CPIO is still expected to apply his mind, see the reply of the third party and then decide. If the third party says don't give it and the CPIO is convinced that there is a larger public interest, the CPIO can still disclose it. But then the consequences will be faced by the CPIO. Now if the information is not available, you don't have to create it. Many times I have seen the CPIOs, when the information is not available, they are asking from here and there and try to generate that information. The Act says that information that is available is to be provided. One doesn't need to create the information to provide to the applicant. Same as if information is no longer available. This was in fact a PGI's case in which the information was weeded out as per the procedure, as per the laid down procedure and with the competent authority. So it could not have been provided but there was record that this information was weeded out after certain period, because that is what the defined period to weed out that information. Now, in this case, the appellant put questions in the form of inquiry which was rejected by the CPIO, and the CIC observed that Act does not make it obligatory on the part of the public authority to create information for purpose of its dissemination. Information would mean any material in existence and not something that has to be created. Making an analysis of data or deriving certain inferences, conclusions based upon the data so collected cannot be expected to be done by the CPIO. Answering a question or proffering advice or making suggestions to an applicant is clearly beyond the purview of the RTI. I will just finish. And also RTI is not about seeking answers or seeking questions, or many times the information is available in the books. I have seen that CPIOs are copying that information and providing it. That is beyond the purview of this Act. We have to provide the information that is under the purview of that public authority. We just can't copy and provide Swami's book or some Harrison's book and provide that information, because those books have, those authors have copyright on those books. Thank you. Oh, I still have 5 minutes. So RTI is also not about asking opinions. Information was sought in respect to certain test methods followed by the police by putting various queries to ascertain whether it is confirming with the medical standards. The CPI of PGIMER denied the information that saying that it is not covered under the RTI. The judgment was that the appellant is seeking only opinion of the CPI regarding some medical test and dismissed the appeal. Now, pending departmental inquiry, most of the time it is the applicants themselves, most of the time it is the staff who ask such kind of information if a departmental inquiry is going on against him or her, or if a colleague. So we have to see, the CPIO has to see if the disclosure of that information would impede the process of investigation or not. And whatever decision he or she, a decision has to be an informed decision, a considerate opinion or a decision. And we'll have to face the consequences about it. To be on the safer side, I usually do not disclose any, if I have an information of the departmental inquiry that is going on, because it may impede the investigation process. So in this case, the CIC held that the department inquiry was a pending investigation under the law, and the same attracts the provision of section 81H. However, once the report of departmental inquiry can be, the report of the departmental inquiry can be shared with the concerned employee and is not barred for disclosure under any of the exemptions provided under section 8(1) of the RTI Act. Public authority can protect the interest of the witnesses or other persons whose name appear in the report by not providing them to the applicant. So the section of severability we can use there. Now the patients who are under detention also have the right to information. In this case, the IBHAS in Delhi actually had denied one of the patient who was under detention about his medical record, but the CIC said that just merely because the patient is under detention does not mean that the patient does not have the right to information. Now, many times what happens that I am the CPIO, the information is held with someone else, and I do not have a direct administrative authority on that. And the person is not providing information, or is having some evasive tactics, or is providing the partial information. So the Act actually empowers the CPIOs under Section 5.4 and 5.4 and 5.5 that they can actually use this and ask the information from their colleagues. So the Section 5.4 says the Central Public Information Officer or the SPIO, as the case may be, may seek the assistance of any other officer, and any officer whose assistance has been sought under Section 4 shall render all assistance to the Central Public Information Officer. And for all those purposes, he or she then becomes the deemed PIO, and deemed PIO have actually been penalized by this SICs and CICs when they have not provided the information, and CPIOs have not been penalized in such cases. If the CPIO could establish that it was not his fault, it was the person deemed PIO who either has not provided information despite repeatedly reminding him or her. Secondly, if the CPIO can also propose a departmental inquiry against such delinquent officials. So in summary, the information is any material in any form. It has to be existing. One is not required to create just to provide to the applicant. The disclosure of personal information which would cause invasion of privacy of an individual is exempt from disclosure unless the CPIO is satisfied that it serves a larger public interest. In case of a third-party information, the third party has to be taken into consideration, but it is not a veto. The CPIO can deny frivolous, voluminous information which disproportionately divert the resources of the CPIO or the public authority. And the reason of denying information must be explained to applicant, and merely quoting the section or a subsection of the RTA is not enough. Providing information is a rule and denying should be exception, and as per the Act there are some exceptions available while providing the reasons as well. So thank you very much. Say again. Which one?
Please.
Not I, sir.
Okay.
Thank you, Dr. Devnani. That wonderful topic, very nicely dealt.